My lord, I beg to mention for item 13 and 14, my lord. My lord, I could not prepare myself, my lord. Maybe kindly taken up after election, my lord. Any 10 or 13, 14? Any date, my lord. My lord.
May it please your lordship. Your lordship, I beg to mention item number 4, your lordship. In this matter, I pray for 4 weeks accommodation, your lordship, because your lordship, some instructions are still awaited from my client, your lordship. With regard to the birth
Let the
certificate,
matter reads, we'll consider your prayer.
my lord.
Right, to your lordship. Lordship, item number 21, as per your lordship direction on the last occasion, lordship, because the brief has been taken away by the client lordship. So we have filed our affidavit. There is a letter we have sent to the petitioner,
Mr. Sarma, just wait, but just wait, you pass the.
lordship.
May it please, Lordship, with regard to item number 3, my lord, I'm praying with the matter may be agent for the day, my lord, any week, next week, my lord.
Let the matter reads, you pass the.
My lord. Highly agree.
May it please your lordship. My lord, in this case, my lord, in fact, my lord, I have been engaged yesterday, my lord. So, my lord, may I pray, my lord, some accommodation, my lord.
Mr. Substitute, and it's senior counsel for the petitioner, you are assisted by whom? P. Chakravarti. P. Chakravarti for the petition. Also heard Mr. Yeah, list, indicate William. Yeah, for Mr. Real Standing Council, Commission, for the response number 2. Mr. Zison, Standing Council from Department for the response number 3, 6 and 7. And Mr. P. Sharma, additional senior for some for the response number 5.
Lordship.
Sugun. Dependent message is. Interim section, interim bail, 19/04/2022, both steps on or before Friday. The two Friday. Subject to the compliance of interim. Just a minute. It is biometrics class. So let in the records. This is from the foreigners tribunal, Bongaro number 2 of April, portion of the 19. Just for hearing on it. Yes, you take steps. We have issued rule,
My lord,
records to be written,
my lord,
and the matter will come for hearing.
my lord.
But take steps on the respondents
My
on or
lord.
before Friday.
Highly.
May I please your lordship?
You have just copy.
Sir,
Whether your junior has filed Wakalatnama?
Yes, my lord.
When did you file?
Today.
Give the names. Register
Number,
select the name. Such as was listed. One petition.
Highly.
Yes,
your lordship, on the last occasion, I directed this matter to be listed for orders. But somehow it is again.
doesn't matter.
Yes, sir. Your lordship, I had also mentioned on the last occasion that my senior who was appearing in this matter, she has filed an application for withdrawal of her from the of her Wakalatnama. So we have filed an affidavit to that effect yesterday only.
Have you sent register notice to the,
We have obtained an NOC from the petitioner
when did you file that?
yesterday.
Have you received a copy of the affidavit, Mr. Sharma?
No.
Have you served the copies to someone?
No, your lordship, we'll serve it today. only.
Borua, call quick. We'll take it after something.
Yeah.
Maybe.
This repetition is against the final order passed by London Foreigners Tribunal, Udalguri. In FT case number UEL oblique FT oblique 3032 oblique 2016. Whereby petitioner has been declared to be a foreigner under the Foreigners Act 1946, who had illegally entered and territory of India within the Assam on or after 1971. Pursuant to the order of the court dated 02/09/2020, registry have received the relevant records from the concerned foreigners tribunal. Issue rule, return every 166. Ready, steps on the response number 5. By registered posted to the owner of the. Appear before the Superintendent Police Board of Udalguri on or before 22nd.
Highly attachment.
List this matter for you.
Deeply obliged.
Take steps on the respondents on or before Friday. Subject to
Please, Your
this.
Lordship.
Mr. Sharma, see, you have to keep a track, what happened? The earlier the record did not was received because initially it was at Silapothar, the tribunal of Dhemaji at Silapothar, this particular tribe. Then, the record shows that it was shifted to Dhemaji. The order was passed by Dhemaji bench. Now, this matter relates to Silapothar. So that was, again, there is a Foreigners Tribunal now at Silapothar. All those records after disposal have been sent down to the Silapothar. So after the inquiry, we come to know that it is the record, it was not released by the registry because it was the note went to the Dhemaji, not to Silapothar.
Yes, doctor.
So you must have the list during which period, which particular tribunal has been shifted. Now, say for example, Jorhat. Jorhat is looking after Soraideo, Sibsagar and Golaghat also, I think.
Yes, doctor.
So like that. So this, where there are two or more different places, like
Yes,
in
sir.
Kamrup, we have at Ramia, we have at Tamilgaon also. Similarly at Boko.
Yes.
So there are many benches, there are many tribunals at their various places. You should categorize.
Yes.
You should have that list and at least give it to us. So that is why the record did not reach the registry earlier, though it was called for.
Yes,
Okay? Question to our earlier order. This repetition. But the petition is against the order dated 14/12/2020, passed by Learned Foreigners Tribunal, Dhemaji Second, Assam. In case number F.T.05/2019 within bracket capital D. Whereby she was declared to be a foreigner under the Foreigners Act 1946, who had illegally entered in the territory of India. In bracket Assam, in order of 25/03/1972. Matter pertains to Foreigners Tribunal with Dhemaji at Silapothar. Though the impugned order was passed by the Foreigners Tribunal, Dhemaji, on 14/12/2020. issue rule, written over steps. Friday. If we have before Superintendent Police Board at Hemaji on or before 22. Condition. Written the records received from the Furnace Tribunal, Hemaji at Silapur. Okay, take steps on the respondents and if you have before the tribunal.
My lord, if I may make a submission, my lord, on my lord, 25/9/2023, your lordship had raised some queries with regard to the birth certificate of the petitioner here, my lord.
Look at it at the time of hearing, and not at this.
My lord, I may be allowed to file additional affidavit bringing in record the certified copy of the birth certificate, not birth certificate, but the order of the magistrate, my lord.
Put it at the time of hearing. We are
Right.
not saying anything at this.
Congratulations.
Taking steps in subject to-
Yeah, Mr. Lordship,
Yes, ma'am.
my senior is election, my senior is election code number 1. Kindly your lordship may pass about the matter for the time being.
What's your good name?
B. Setia, Bhagyasree Setia.
For the petition. Mr. For election commissioner. Eastern Standing Council for us number 3, 6 and 7. Mr. Fisher. For us number. Written by 6. Steps on the responding others, on the responding bus. 4 by registered. Subject to the. Yes. Madam Teacher also. Subject to the interim order, 8-12 interim protection. Awareness tribunal number 7. Take steps on the respondents. And the respondent number 5 by raise support. On or notified.
May it pleases your lordship. Well, looking from the last petition, your lordship, a matter pertaining to not with filing, not registering the FIR. Lordship, I would like to take you to the page 155 of annexure 17 of the petition. 155.
Yes.
Addressing to the officer in charge OC Hoiberga, Post Outpost, District Nagaon, Assam. That has been prior to file a FIR, your lordship, on dated 14/11/2023. Your lordship, this FIR can be taken as a cognizable offense, your lordship, as they had mentioned it on next page, your lordship, page 156. Your lordship, very last line, last 3 line, your lordship. Page 156. Last 3 lines, I would like to read, your lordship, that on dated 4/11/2023, Mr. Vishal Agarwal with his manager of MSRD Motors along with his muscleman Gundas approximately 50 to 75 forcefully attacked me and my son as Rajasthani Gunda style breaks out the locks of the classed rooms of aforesaid building premises, and thereafter, your lordship, 157, your lordship, destroyed furniture.
Just a minute. Mr. Sharma, earlier also similar matters cropped up and matters was listed before this. court. Then the DGP Assam. Yes. Specifically instructed all the officer in charge of all the police stations, superintendent of police of all the districts, as well as the officer in charge of all the police stations of Assam to register a police case, which if the FIR discloses any cognizable offense. In terms of the constitution bench judgment in the case of Lalita Kumari, and it was placed before the court. Now, we want to know why this FIR lodged by the petitioner on 14/11/2023 before the Hoibergaon post outpost. Normally what happens, if it is registered, if it is submitted before the outpost, it is sent to the concerned police station by the officer in charge or whoever in charge of the outpost. So today is 22nd, today is 30th of April. Elections in Nagaon district is already over. Right?
Yes, Your Lordship.
We want to know it on 8. Status of this case. List on 8. And on the same date, the Superintendent of Police Nagaon shall apprise the court as to when the FIR of the petitioner lodged on 14/11/2023 before the Hoibergaon
Outpost, post out. District Nova.
Officer in charge, OC Hebergaon Post Outpost.
then it will D, capital D, outpost. Was registered. Hoibergaon outpost is under which police station?
Noga.
Nova.
Noga Hebergaon.
Registered. The number of the concerned police station case and registered. And the action taken. That's of action taken. Police case. Petitioner shall furnish 2 extra copies of this petition along with the annexes of the Mr. P. Sharma, additional civil engineer Assam during the course of the day. List according. The list must say it.
Deeply obliged.
Take your seat. Yes, Mr. G. Sharma, some order was passed earlier. Something was there, I forgot. You have the record.
Government to obtain instruction as per last order.
No, Mr. Sharma is supposed to present, Mr. P. Sharma.
We have not received that data. Election is there, my lord, data. So sometime. For extent.
On the prayer of, as Malada presently parliamentary election.
Barpeta.
the district of Nalbari. No, parliamentary is going on and the district of, the deputy commissioner Nalbari is the concerned election officer of the Oxide district. Mr. P. Sharma, and additional senior governor, some raised for some more time to provide the relevant record. Sought for by the court in this petition. Prayer allowed, placed on 28th of May.
My lord, only one submission, my lord. My lord, some interim protection may
But
be.
till 28th of May, nothing will happen. If you are arrested now, you will not get the vote, so no two will arrest.
Obliged, my lord.
Artist Mr. Ranu Patel and council hearing for the petition. So not 2, 4. Oh, wait. Intention. They go. Go now, finish it. For the response number 5. This petition by the petitioner is against the order that the 2011 to 2019. Caused by Leonard Furnace Tribunal Jorhat. In every case number FD of the SVR of 55 of the 2015. By which the petitioner has been declared to be a foreigner under the Foreign Assistance very illegally entered. India will look at some of pursuant to the order of the court dated 19/05/2020. That they have already received the relevant records from the Venice Tribunal Judge. So, can able to appear before Superintendent of Police Board of Sibsagar.
Sounds like a bit.
On no bill.
Almost like
Steps on the response. Not the steps will be. Responded number 1, 2. Okay, Respond number 6 by register poster. Less for reading on the implementation. Yes, Mr. Upadhyay asked the petitioner to appear before the Superintendent of Police Board of Sibsagar on or before 22nd.
In this matter, we have withdrawn from there.
You have withdrawn.
As a
Did it-
council, on the last occasion, the lordship directed us to file
In that case, you file an affidavit.
an affidavit, so we have filed our affidavit.
When?
It is on 23rd of April, lordship,
Okay.
and
We pass the order as soon as we get the affidavit.
lordship.
With the affidavit.
And similar case is pending before this honorable court. And record has sent to death with petition lordship. Same name lordship Usman Ali. Yes, Usman Ali. Same record. Lordship में both the cases may be clubbed together.
Place this matter for admission on 10th, along with the records of WPC number 5610-2017, custody. Sharma, 5610-2017 pending license. Pending us. Last detail is. Leave this matter along with the records of WPC number 5610-2017 on for the hard Mr. Upadhyay for the petition.
PN confirmation.
It is seen that the petitioner has taken back the brief from Mr. Upadhyay
Lordship PN Sharma.
on, sorry, P.N. Sharma on 04/06/2023. And thereafter, from the chamber of Mr. Nageshan, London Senior Court. Did not return the same. As such, Mr. P. N. Sharma, London Council, on behalf of Mr. Arbishan, on 05/04/2024, sent a registered letter to the petitioner regarding the withdrawal from the brigade. Requesting him to engage other lawyer to pursue his case as the brief has been taken back from them. Placed on 14th May. Let it be 30 days over.
Lordship.
We'll see.
Make three your lordship.
Lordship, on the last day, your lordship, perhaps call for the LCA, your lordship. And since it has come, your lordship.
Notice in this case was issued on 14/05/2018. Registry have received the relevant records from the Foreigners Tribunal 8 Sonitpur. In a summary. Issued will returnable by such and such. Shall appear before the Superintendent of Police Board of Sonitpur on or before 22nd. For capturing this biometrics, iris, fingerprints, steps on the respondents on or before Friday. That's the matter for hearing, such and such. KPR before the inspector, Superintendent of Police Board,
Your lordship, but I was already on bail.
not for bail, for capturing your
Almost. Lordship, lordship.
biometrics. Notice in this case was issued on 30/03/2021. The registry has already received the relevant records from the Foreigners Tribunal second Council. Issue will already steps on the response. Biometrics also,
Lordship, matter will be taken after some time, dinner will appear. She is on leg in court one, lordship.
In this matter, my lord was pleased to call for status report as to the judicial inquiry, my lord.
Reports has come, lordship. Video. Report to DDO this sector. Report will take time to do it. Report data level.
Mr. Sharma, to him, Mr. Chaudhary. Mr. Chaudhary, it appears that inquiry is still going on. It has come from the concerned magistrate. So we have to wait for some time. Because it's a judicial inquiry, right?
It is usually as
From the communication of the Superintendent of Police Kokrajhar, the date 22/03/2024, as well as the sub-divisional judicial magistrate within bracket M Gosaigaon, the date 21/03/2024, placed before court by Mr. P. Sharma, Lani Additional Senior Government Advocate Assam. It is seen that the that the judicial inquiry in connection with Gosaigaon Police Station case number 23/2021 corresponding to GR case number 30/2021 still going on. Where the statements of the 11 witnesses are yet to be recorded, to whom notice of like summons have already been issued. List on. July 17. Enabling the SDJM Mudin Becket M Gusaigaon as well as the Superintendent of Police Pokrajar Assam, Pokrajar, to place the up-to-date status of the judicial inquiry in connection with Chain Gusaigaon PS case number 23 of 2020. Communication dated 22/03/2024 of the SP Pokrajar as well as communication dated 21/03/2024 of the SDJM Mudin Becket M Gusaigaon be kept part of the record.
Pilot next.
Repeat करना है।
One opportunity is accorded to the petitioner to appear before the tribunal and place his case. Petition is allowed with cost of rupees 3,000 to be deposited before the DLSA. And a copy of the receipt will be taken along with the copy with this order and appear before the tribunal.
Honorable Court.
20 on, the petitioner has to appear before the tribunal on 27/5/24
On or before, my lord. Any day I will. Be there.
on
On or before.
one date.
What sister has said that along with the, first you have to pay the cost before the DLSA. And then along with the receipt, you have to appear before the concerned tribunal with the certified copy of this order. On or before 27th of May 2000.
Hello.
Saying that you are required to file your written reply, public written statement as well as written evidence in affidavit, along with the documents on the basis of which you claim to be an Indian.
For regarding item number 12.
May it please, your my lord, here also kindly have a look at the order dated 10/8/23, my lord. Some reports were called for, my lord.
Yes, Mr. Dipti.
এখানে স্টেটে নিবি মজা
Last year, there was an order.
Yes.
Directing you to place all the relevant records.
The inquiries are done by the state authorities, Lordship.
Yes, Ms. Sharma, who is holding the records? Mr. Sharma, any one of you appear and tell us who is having the inquiry? One conducted by the additional district magistrate, another by the additional chief secretary.
Lordship, we have not received that.
Pursuant to the order of the Assam Human Rights Commission. There's an independent police inquiry. So what Mr. Dev Chaudhary submitted on that day, there are 4 enquiries in the same incident. You are required to give us all the 4 enquiries.
Keep us. Additional chief secretary report to court.
This is by whom? This is incomplete. Last page is not there.
This matter is from SP Chiram Naik.
Last page is not there.
Last page. Yeah.
This is by the police inquiry. There is other inquiries. The report recorded, there are 4 inquiries. One is by the additional district magistrate. What is that?
District Minister by the additional chief secretary.
This is pursuant to the direction of the National Human Rights Commission.
Yes, additional chief secretary government Assam. That is.
Where is the others?
That report, we have not received that. Sometime.
আমার অ্যাফিডেভিটত আপনি প্যারাগ্রাফ 17 ছিল না এটা আছে লেখা ম্যাজিস্ট্রিয়াল ইনকোয়ারি additional chief secretary inquiry HS independent inquiry by IGP
Another report was there. My lord, there is a magistrate inquiry. We have received that on 25/8/2023. Oh, my desire is okay. All of us.
my affidavit to paragraph 17 to sub nata লেখা আছে কি কি আছে
We should. That's not a very good tool. What else? Details of the ministry report. Interview party. কোনটো আছে 1 minute. Hmm? 1 minute. Human rights to unemployment. We have not received that, for human rights report, not we have not received. Other 3 report, my lord, we have received.
From the order of the 10/08/2023, it can be seen that with regard to the incident involved in this petition, already there were 4 enquiries. From the affidavit filed on behalf of the respondent numbers 1, 2, and 3. It can be seen the following 4 enquiries were conducted, namely Roman 1, small Roman 1. Following enquiries, which are as follows. Conducted on the following enquiries with regard to the incident in the case took place, which are as follows. Small Roman. District Magistrate Komachirang ordered a magisterial inquiry into the incident on 11/12/2013. Pursuant to which the additional district magistrate Chirang proceeded with the said inquiry. Roman 2. The government of Assam on 15/12/2013 inquired, it directed an order for 1-man inquiry with regard to incident to be conducted by an additional chief secretary level officer that commenced on 07/01/2014. 3. The Assam Human Rights Commission took up a suo motu case and directed the government of Assam to conduct an independent inquiry by an additional chief secretary level officer. 4. An independent police inquiry with regard to the incident was ordered by the in-charge IGP Boruland Territory to be conducted by the additional superintendent of police Kokrajhar. Mr. P. Sharma, additional senior government advocate Assam, placed an inquiry report dated 28/02. 2014. Inquiry report relating to incident involving district petition. Submitted by Surjit SURJWT, Singh SIMGH, Panesar PNES, Additional Superintendent of Police Headquarters would be called in bracket. Kokrajhar within bracket, BTAD Assam. As well as the enquiry report dated 11/03/2014 of Additional District Magistrate Chirang Kajalgaon. On the next date fixed, the state respondents in the Home Department shall place the other two.
One, we have received one.
You have,
No, the one man
What-
inquiry report is there.
Yeah.
Only one report is available.
We have it,
doesn't matter.
Three out of the four reports.
one report, we have it.
Mr. Sharma has also placed the copy of the enquiry report, one-man enquiry report. With regard to the incident conducted by Mr. V. Pyarelal, did an additional secretary of the state enquiry report dated 18/9/2014. This is now pursuant to the Human Rights Commission's order or by, because there are two one-man committee. One in terms of the order of the Assam Human Rights Commission. And another, just a minute, we'll get it now itself. Okay. This is pursuant to the order of the state government dated 15/12/2012.
The 15/12/2013.
The fourth report put together the incident in terms of the order of the Assam Human Rights Commission is yet to be received. Or the next date fixed. The respondents in the Home Department of the state by way of an affidavit shall place all the enquiry reports, legible enquiry reports. Before the court, serving a copy of the same on the counsel for the petitioner. Placed on 28 May We have sufficient time, give us the legislative officer. On the next, honor before you. 24/05, correspondent from department shall by list this matter on 28.
My lord,
Take this copy.
can I add one, my lord, here? By the petitioner side also, there was one FIR, my lord, independent of the other case, my lord. So regarding the same incident, my lord, one by the army authorities, my lord, and one by the petitioner side,
These inquiry report will have everything. Let us see.
my lord. Just I am placing before the court, my lord.
Is there any other case pending?
One FIR is there, my lord, by our side, my lord, by the petitioner side.
Very good. What is the case number?
That is, my lord, Runikata Police Station, 30/2013, my lord, lordship find case 7, para 9, my lord.
The respondents in the Home Department of the state, as well as the Director General of Police and the Superintendent of Police, Director General of Police Assam, as well as the Superintendent of Police Chirang, shall apprise the court about the status of Runikata Police Station case number
30/2013.
and the next that fixed,
As well as 28/2013.
as well as they are lost by
By the
pursuant to the FIR lost by who was the complainant informant
our case, my lord, it is the petition number 1, my lord.
lost by
And it's,
who is he?
my lord, Tijan Narjari, my lord, there is
Anjan
number 2.
Narzari or Tijan Narzari?
Tijan, my, he will be number 2 possibly, my lord.
Is the brother of the
Yes, my lord,
deceased
my lord,
by the petitioner
number 2.
number 2 Tijan Narzari, as
My-
well as this is all Runikata outpost,
Yes,
Runikata police station case number
28/13, dated
28/2013. That was registered on the basis of an FIR lost by
The army.
the army. Copy of this order before furnished to Mr. P. Sharma, additional chairman government Assam for this necessary use. Go,
Amlaj.
Report complete and legible.
My lord, the impugned order in the present proceeding, my lord, lordship will find at page 62.
Mr. Mandu, that's few minutes. Yeah, take your seat, come back. Longer, longer than that. Who is appearing for the respondent? Mr. Sharma, Mr. Pang. Yes. To prove her linkage with her father, Romejuddin Sheikh, the petitioner exhibited few documents before the tribunal. Now, one is a certificate issued by the circle officer, Bogriwari Revenue Circle, that is Exhibit D, which is an excerpt. 20 in the present petition. Then one copy of 1951 NRC. Annexure 9. That is Exhibit E. Then another NRC. Annexure 10. And the evidence of the Latmundal of Bogriwari Revenue Circle, which is Annexure 21. In the written statement, as we have seen from the record, in the writ petition, if you see at page 25, there is a page missing here in our copy. After paragraph 5 at page 25, the next page at page 26 is starts with paragraph number 12. I don't know about you. What is your copy?
Same.
But there is no mention from paragraph 6 to 11 in the writ petition.
Yes.
You have not checked while filing. No, that's page number 46.
Yes.
You do not have the paragraph 6 to 11 in the writ petition. Anyway, The same is available in the record. You have that particular page, Mr. Mandal.
And please.
Okay. Yes, Mr. Pine, you can go to the second page of the written statement of the book.
Yes. Absolutely. Yes.
Read the page number 51 of the record.
The 1 month. This is the honorable member for University Tribunal, verification of certificate of NRC with reference to certificate of I turn out the income reflectors scrutiny available register number 20 order branch found the name of the central inter register as house number 20 is found correct. This is per bank credit.
Now, if you go to the records, you will see the written statement, there is no mention about
NRC.
the
NRC document.
annexes.
About the annex 1011 money.
Probably. Seven and 8.
In fact,
Now, the case of the petitioner is that she is the daughter of one Tamizuddin. Existence of Tamizuddin in Indian soil
yes.
prior to 1971. Is there any document before the tribunal?
No one. Except that NRC. NRC
But NRC
is
settled long back.
yes, Manoj. NRC is
It's not a document for that
so that
purpose.
cannot be used as a document for the purpose.
What
So,
in the law is there is it has to be a continuous state. Person they continuously to be residing in India prior to 1971 and thereafter.
Yes.
And that is why on most of the occasions, the procedure is to show the voter list of their projected father, grandfather, the voter list prior to 1971, and after 1970.
Yes. First of all, the main thing is that either petitioner has to show he was born in India by any means prior to 1971, or his father and mother, parents are citizen of India prior to 1971, and then take the name.
The case of the petitioner herein is that her mother married another person.
That is that effect I was coming, my lord, in the
And then
WS.
she was taken care of her stepfather.
There is a contradiction to that in WS itself, my lord. Your lordship may kindly see para 8 of the WS.
This is not before us, you have to
Yes,
read.
my lord, may I read the para 8 of the WS? That the father's name of the opposite party has been recorded in the voter of 1977 by serial number 64395, house number 74 of village Khargata, under 26 Bidasipara, LSC, district Golpara, present district Tuburi, Assam. That is in para 8. My lord, that is in para 8. However, this document is not exhibited or not annexed by the petitioner. Now in para 11, my lord, same in the same WS, para 11. That is in para 8, my lord. Para 11, that the fathers of the opposite party died prior to 1960. Died prior to 1960. Thereafter, her mother, Yaman Bibi, married another person of village Khargat. Accordingly, Montaz Ali, husband of the mother, was the caretaker of the opposite party. There is two pleading in the same mother. First of all, in para 8, she has stated that father's name of the opposite party has been recorded in the voter list of 1977. But if father's name was recorded in 1977, and in the same manner, after two para, she has stated the father of the opposite party died prior to 1960. Thereafter, her mother, Yaman Bibi, got married to another person, Montaz. The WS itself, my lord, she herself contradicted the
Whether the record has any 1977 voter list
my lord, 77 voter list she has not submitted. She has
of
submitted
her, of
of her
father.
herself. She submitted of herself, that is exhibit C.
Annex of 15 here.
This exhibit C is the voter list of 1977, where she has claimed that her name is appearing in the 1977 voter list. Yes, exhibit C. Exhibit C.
In those paragraphs, is there any mention regarding the grandfather of the
No.
projected father?
No, nothing. Not mention anything about grandfather. The grandfather name is mentioned in para 9, madam. The opposite party is the daughter of deceased Thomasudin Singh and granddaughter of late Hawaii of village Khargat,
PS Bogribari under Circle Bogribari. According the officer of Bogribari Revenue Circle, officer issued a link certificate in the name of opposite party on 6/8/2015, which is signed by the Lat Mandal and countersigned by the Circle Officer Bogribari Revenue Circle. And then Paratin, the father's name of the opposite party has been recorded. He has stated again, madam, the same para 8, recorded as Tamishuddin, son of Soinsho, in house number 6, house number 36 co of village Kargata under PS Bilasipara, district Kolpara, present district Thupuriasa. Hmm. 77 voter list.
Any voter list of her mother?
Her mother, my lord, there is Yaman Bibi. Yaman Bibi, no. 97, 77, her mother is
Name of her mother is there. What is the name of her mother?
Yaman Bibi, my lord. Yaman Bibi. Yaman Bibi. It's Yamana Bibi.
Okay.
Yamana Bibi.
In any voter list?
1977, my lord, only 4 persons, Zahiran Bibi, Mosiran Bibi, Idjan Bibi, Meher Ali Sheikh. These
That
are the
of course relates to the petitioner.
Yes. And prior to this 1977, then 85 Meher Ali Idujan Bewa. Idujan Bewa. And there is thereafter 2011 and 1997. 97 voter list Meher Ali, Idurjan Bibi, Insan Ali, Ismail Sheikh, my lord. And 2011 it is Meher Ali, Idurjan Bibi, Insan Ali.
Give us the record. Now, what do you have to say about this certificate issued by
my lord,
the Circle Officer Bogribari? Please come to page number 59.
My lord, that is the Circle Officer. In fact, that is not issued by the Circle Officer. It is issued by the, my lord, the Lat Mandal, and it is countersigned by the Circle Officer. And the circle, my lord, the person concerned who has given that certificate, he deposed, and he has stated that he has issued, that he has no record of any kind to issue that certificate.
Where he has stated?
Page
Whether
6.
he stated that he issued it from record or what?
No, I have, my lord, your lordship,
Yes.
page 60, my lord. On oath, I am the Lat Mandal of ASO Office, Bogribari Circle. I have appeared before the Honorable Tribunal on behalf of the ASO Bogribari. I have submitted my identity card, compare with original. Exhibit D is the link certificate issued from our office. In this certificate, it is certified that Iduzan Bibi is the daughter of late Tamizuddin Sheikh. Exhibit D is my signature. Exhibit D1 is the seal and signature of a circle officer. It's the round seal of our office. This content certificate is true. He has said that the contents of the certificate is true, but he has not issued, on what basis he has issued certificate, that is not disclosed. He has not said, my lord, he has issued this certificate after proper verification, nor he has said that he has issued this certificate on the basis of any record. He said that this certificate is true. I have issued this certificate, and this is my signature. That is a link certificate. In fact, my lord, first of all, my submission will be, even though this certificate, my lord, is proof, or there is a certificate, but this does not say that he is a citizen, because first of all, the petitioner has to show that the father of the petitioner was existed in India prior to 1971. To that effect, there is no document. Because the NRC documents as settled, my lord, that cannot be used as a piece of documentary evidence. Further, the NRC document was issued by the police officer, who is not authorized to do that. Police has no, my lord, he is not the record keeper of that particular documents. He is not the authority to issue it. And it is settled position, my lord, the NRC of 1951 documents cannot be used as a documents for, my lord, or as a evidence.
Yes, Mr. Mandal.
Yeah.
May I please, Your Lordship? My lord, first, my lord, I will draw your lordship attention. The purported mechanical inquiry report that your lordship will find at
Did you
page,
challenge that before the tribunal
page 18.
in your written statement?
Yes, it was not challenged before it, but it can be challenged in any stage.
Is it?
Yes. My lord, page 18 lordship will find. Now, this is the, my lord, format for verification officer's report. Here lordship will find page 18, only name and my lord, address says my lord Kuragat, and husband's name Meher Ali, and finally says document not produced. And all other columns are blank. Then page 19, lordship will find each and every column, column number 10 to onwards, blank. Then page 20, same, blank. Then page 21, lordship will find this is the my lord, crucial my lord, issue, column number 16, 15, whether migrated into Assam, lordship will find there is a column, my lord, yes or no, nothing has been. Then 16, if yes, place from where migrated, nothing mentioned. Estate, country, nothing. Whether migrated. Now these three groups, my lord, on 66, between on 66 and 24/3/1971, on or after 25/3/1971. This column are, my lord, untouched. So this, my lord, report is, my lord, purported and mechanical, as held by the Honorable Court. Lordship is ever. Yeah,
This is of which date?
my lord, date is not, my lord, given, my lord. Okay, lordship, on record, lordship shall. First report, na? Statement.
Please come to page number 23.
23. Yes, my lord.
Kindly read.
Page 23. Forwarding the voter case number so and so, so and so. I have the honor to forward here with the case of doubtful voter in respect of Yadin Bibi, wife of Meher Ali of village Kuragat, PS village district Dubli, who was received this ink from the so and so for LLC in his her nationality status under the Foreigners Act 1946, and the rules made thereunder. As per report of the ERO, there is a reasonable doubt whether the person is a citizen of India or not. Hence, the case is forwarded to the Foreigners Tribunal for adjudication. It is submitted that the case was initially forwarded to this office by the ERO concerned for determining his her nationality under the IMDT Act 1983. However, that time the IMDT Act 1983 and the rules made thereunder were scrapped by the Honorable Supreme Court, by order dated so and so, so and so. Accordingly, the case was converted to FT case in this office by FT number so and so, sent for field inquiry. However, the case is still pending due to non-cooperation of the deporter concerned. And close.
So thereafter, come to page number 24.
24. This is my lord, a notice. Whereas a reference has been made against you by the competent authority to render opinion on the allegation that illegally entered into Assam without any valid documents after 25/3/1971 verification, 1/1/1966 to 24/3/1971. And whereas, as the reference reveals that you could not produce any valid document during the inquiry verification regarding your Indian citizenship. And whereas on the aforesaid grounds you are suspected to be illegal migrant to Assam, you are hereby directed to appear before the tribunal on so and so to file witness statement along with your supporting documents, if any, to prove that you are an Indian citizen towards discharging the burden of proof as advises under Section 9 of the Foreigners Act 1946. Please note that you will have to appear in person along with your engaged counsel, if any, and will have to remain present personally on each and every date as may be fixed. Also, note that the reference is required to be answered expeditiously adjourned, will not be granted merely on asking for it. This is the notice.
See, Mr. Mandal, we've been consistently discussing this issue. What happened? Though the Foreigners Act was there and the tribunals under the Foreigners Act needs to be, and the Foreigners Order 1964 is to be constituted. In Assam, the illegal migrant determination of the Tribunal Act 1983 came into force. Tribunals under the IMDT Act constituted. After the IMDT Act 1983 was first set aside by the court being illegal, all these issues, whether a person is a foreigner or not, but you'll be seeing in most of the cases, even in this case, the notices has been issued to the proceedee as illegal migrant. The question of illegal migrant is not there by the time when the Sarunda Sonal one was decided. The question of illegal migrant cannot come. It has to be either a foreigner or not a foreigner. So the reference forwarded by the Supreme Police here order is very clear that it has been converted to a foreigners tribunal. And the tribunal directed the proceedee here to submit her written reply to prove her nationality as provided under Section 9 of the Foreigners Act. So, whatever the reasons is there, that periods, illegal migrants, that was there basically in the IMDT Act. And since it is no longer in force, question of period will not come after 2001. And that is why in the Muslim Mandal also, there's a specific direction that the fresh notice has to be issued under the Foreigners Act.
Yes.
So that period being not there in the Foreigners Act,
yes,
whatever the issues raised, decided by the court is immaterial because there is no question of any period or date or whatever. So now the question remains whether a proceedee to whom such notice under the order to one of them issued by the Foreigners Tribunal have to prove his her nationality.
Yes.
Giving evidence under Section 9 of the Foreigners Act. Now, some notice might give some limits or whatever. We are not on that. First of all, initially it was the determination by the local verification officer was under the act, and it was very specifically, you have read the report of the Superintendent Police Board, Hubli, when he referred the matter to the foreign minister. Say that initially it was done, this report without any document, and now the inquiry report is having come, but there is a doubt that has been expressed. Now, if you go to the Foreigners Act and the Foreigners Orders 1964, will you be able to show us that there is a requirement of any inquiry by any LVO or anything? But it clearly says, section 2, you'll see, it is the concerned authority of the central government. Right? There is, even in the rules or even in, there is nothing.
Yes.
The doubt has to be there. And doubt has to be there, and the concerned authority has to refer the matter to the tribunal for determination, whether he is or is not a, he is or is not a foreigner,
Yes.
that much. Here is a reference made by the Superintendent Police Board, Dhubri, who is the concerned authority, employed by the central government. Refer the matter to the tribunal under the foreigners. The tribunal issued the notice, though has given something, but ultimately directed the procedure to prove her citizenship or nationality in terms of section 9 of the Foreign Act. So entire proceeding starts on the basis of the foreigners. The issues which we have said that the LVO's report is blank, that is blank. After the matter has been taken up under the Foreigners Act, whether those will be material.
Yes, materials. In view of the Muslim Mandal's
Just
judgment.
read the Muslim Mandal's
Yes.
original case.
Yes, original case. Lordship kindly see the full bench.
We are ready to see that. That is why
Yes.
we are always asking Mr. Payang and others who are supposed to that. Look at him.
Yes.
Whether to follow the IMDT Act after it was scrapped by the Supreme Court, or we have to follow the Foreigners Act. Which
Point-
you should follow?
Yes.
Should we follow half of the IMDT Act, or should we follow
No.
something from the Foreigners Act?
Absolutely Foreigners Act.
Absolutely Foreigners Act.
Yes.
Then what is the question of having those periods prior to 1961, in between 61 to 71, or after 71?
But
Where is the requirement?
But the inquiry has to be made.
Where from? Under which provision of the
Where
Foreigners
there
Act?
is no inquiry.
So as the provisions in the
Yes.
Foreigners Act
Yes,
and the
Lordship kindly
orders of
see,
the rules.
we are referring. In Muslim Mandal case, Lordship will find 2013 on GLT, page 809, paragraph 96, 97, 98, 99.
Two 2013,
1 GLT,
809.
809,
Hmm.
parameter 96, 97, 98, and 99.
Paragraphs?
Yes, 96 onwards, madam.
Go.
May I read,
Just a
madam?
minute, just a minute. Take a seat, Mr. Mandal.
Madam.
Come back to you. Take it.
Fine.
Mr. Pang, you have the decision of the full bench decision of the
Yes.
in your hand.
I will reply on that one.
Mr. Mandal. Mr. Pang. Come to paragraph 60 of the Full bench, sir. Clause D. Kindly read, Mr. Mandan.
Clause D, my lord.
There
In
will
what
be-
manner, the investigation is to be carried out by the instrumentality of the state before making a reference to the tribunal under the provision of the 1964 order.
How it is answered
Yes.
by the full bench? Which are the relevant paragraphs for that matter?
After paragraph 92, my lord.
Let Mr. Mandan read.
Question D. In what manner the investigation is to be carried out by the instrumentality of the state before making a reference to the tribunal under the provision of the
Because
1964
the full bench,
Yes.
after hearing the learned counsels for the petitioners, decided that these are the issues to be incorporated in that particular matter and has discussed each of the issues, and D relates to how the
Yes. Now D relates to, now lordship will find there are 93 onwards.
now you read from para 89.
89.
That's where it is there.
There are 89. The tribunal gets jurisdiction to give an opinion on the question whether a person is a foreigner or not only when a reference is made by the authorities mentioned in clause 2 of the 1964 order. The tribunal thereafter has to cause service on the person to whom the reference relates a copy of the main grounds on which he is alleged to be a foreigner. The tribunal is also required to give a reasonable opportunity of making a representation, producing evidence in support of his case, and after consideration of such evidence as may be produced, as well as after hearing such person as may be deserved to be heard, it has to submit its opinion to the authority specified in that behalf in the order of reference. The tribunal, however, is empowered to regulate its own procedure. Clause 4 of 1964 orders confers on tribunal the power of the civil court while trying a suit under this code of civil procedure in respect of the summoning and enforcing the attendance of any person and his examination on oath. B, requiring the discovery and production of the any document, and C, issuing commissions for the examination of any witness. The procedure laid down in the code of the civil procedure as is not applicable in a proceeding before the tribunal except in relation to the matter stipulated in clause 4 of the said order. As noticed above, the tribunal is empowered to regulate its own procedure while deciding the reference proceeding pending before it.
Then 90.
90 minutes. Though strictly speaking, as soon as the tribunal renders its opinion, it becomes the functious officials as no proceedings thereafter is pending. It cannot be said that the tribunal has no jurisdiction to pass an order even after the disposal of the proceeding in the interest of the justice. Courts and the tribunals exist to do justice. It cannot refuse to entertain an application even after the proceeding before it's over on the ground that there is no specific provision in law laying down the procedure for entertaining such application. If such application is required to be entertained to do justice between the parties, otherwise the very existence of the court or the tribunal would be meaningless. If in a given case where such an order is required to be passed, the court or the tribunal refuse to pass such order on the plea of the technicalities, the procedures are handmade in justice and must be regarded as something designed to facilitate the justice and further its ends, and not a thing designed to trip people up. Sangram Singh versus so and so, reporter so and so. Moreover, by the nature of the quasi-judicial proceeding before the tribunal, they have trappings of the civil court. Neither in 1946 Act nor in 1964 order or any procedure formulated by the tribunal prohibits acceptance of any application after rendering the opinion by the tribunal if the entertainment of the same is required for ends of justice.
91.
The apex court in Indus Bank Limited Supra, while dealing with the power of the labor court constituted under the Industrial Disputes Act to entertain an application to set aside its expertise award, has held that there being no statutory prohibition to entertain such an application, the tribunal has the power to entertain the same in the interest of justice. It has also been held that there is no express provision in the Industrial Dispute Act and the rules framed thereunder giving the tribunal jurisdiction to entertain such application. The tribunal should be considered to be endowed with such ancillary or incidental powers as are necessary to discharge its function effectively for the purpose of doing justice between the parties. It has also been held that the power given by the to the tribunal under Section 11(1) of the Industrial Disputes Amendment and Miscellaneous Provisions Act 1956 to follow the such procedure as the arbitrator or the other authority concerned may think fit are of widest amplitude and confer ample power upon the tribunal and other authorities to devise its procedure as the justice of the case demands. The apex court further opined that object of giving such wide power being to mitigate the rigor of the technicalities of the law for the achieving the objects of the effective investigation and settlement of the disputes. The tribunal can entertain an application for setting aside an expertise award. The tribunal, however, is required to exercise its discretion relating to the entertainment of such application in a judicial manner without caprice and according to the general principle of law and rules of the natural justice. The same view has also been reiterated by the apex court in Santam Verma Supra 92 million. As discussed above, the tribunals constituted under the Foreigners Act read with the 1964 order have to regulate their own procedure, and they have also quasi-judicial function to discharge, and hence in a given case, the tribunal has jurisdiction to entertain and pass necessary order on an application to set aside the expertise opinion, provided that it is proved to the satisfaction of the tribunal that the proceeding has not served with the notice in the reference proceeding, or that he has prevented by sufficient cause from appearing in the proceeding, a reason for which was beyond his control. Such application, however, should not be entertained in a routine manner. The tribunal can entertain such application providing the proceeding should demonstrate existence of the special exceptional circumstances to the entertain the same by way of the pleadings in the application filed for setting aside expertise opinion. Otherwise, the very purpose of the enacting the 1964 Act and 1964 order would be frustrated. The tribunal, therefore, would have this jurisdiction to reject such application at threshold if no ground is made out. Now, the question D, my lord, in what manner? That is the now that has been discussed in the following paragraph. 93, my lord. The right to get a fair trial is a basic fundamental and human right. Any procedure which becomes in way of party in getting a fair trial would be violative of Article 14 of the Constitution. Fair trial also includes a fair investigation. The concept of fair investigation and fair trial assumes much importance in the matter of detection and deportation of the foreigners under the provisions of the Foreigners Act 1964 order, as well as the 2000 Amendment 12 order, because of the nature of the proceeding as well as the burden cast on the person who is suspected to be a foreigner to prove that he is not a foreigner. By Section 9 of the 1946 Act, the citizenship right is to be jealously protected. The right under the Article 21 Constitution of India is availed to all persons to protect his life and personal liberty, and hence even the right of a non-citizens to have that investigation, trial, as well as the fair procedure to be adopted by the tribunal is granted under Article 21 of the Constitution. 94. The Apex Court in Darka Prasad Agarwal Supra has opined that the right to get fair trial is a basic fundamental and human right, and denial of fair trial violates Article 14 of the Constitution of India. In Jahira Habibullah, so and so Supra, commonly known as West Bakery case, the Apex Court, giving emphasis on the principle of the fair trial, has opined that the just application of its principles in substance is to find out the truth and prevent miscarriage of justice. It has also been opined that the concept of fair trial and ties this familiar triangulation of the interest of the accused, the victim, and the society and its community, the acts through the state and the prosecuting agencies. It has also been opined that a trial which is primarily aimed at ascertaining the truth has to be fair to all concerned. It will not be correct to say that it is only the accused who must be fairly dealt with. That would be a turning and Nelson's eyes to the needs of the society at the large, at the victims and their family members of the relatives. Public interest in the proper administration of justice must be given as much importance, if not more, as the interest of the individual accused. While dealing with the role of the court, the Apex Court observed that the court have a vital role to play. Its role is to discover, vindicate, establish the truth, and hence the trial should be searched for the truth and not bought over the technicalities. The Apex Court further observed that the presiding judge must cease to be a spectator and a mere recording machine, and he must have active interest and recite all relevant materials necessary for reaching the correct conclusion of the find out the truth and the administration of justice with fairness and impartiality both to the parties and to the community. 95. In Jahira Habibullah so and so, Apex Court opined that every state has a constitutional obligation and duty to protect the life and liberty of its citizens, which is the fundamental requirement for the observation of the rule of law. There cannot be any deviation from this requirement because any extraneous factors like caste, creed, religion, political belief, or ideology. The Apex Court further opined that the fair trial consists not only in the technical observation of the frame and forms of the law, but also in the cognition and just application of its principles in substance to find out the truth and prevent miscarriage of justice. In Samadhan Davoka, Koli so and so Supra, the Apex Court has reiterated its view, and the prosecution must also be fair to the accused. Fairness in investigation as also trial is a human right of an accused. In so and so case, Apex Court, reiterating the earlier view, has further opined that the fair trial is inherent in the concept of the due process of law, and the fair hearing requires an opportunity to preserve the process. In Nirmal Singh versus so and so, Apex Court has reiterated that the fair investigation and the fair trial are concomitant to observance of the fundamental right of the accused under Article 21 of the Constitution, and hence, though the state has a larger obligation to maintain a law and order, public order and preservation of the peace and harmony in a society, a victim of a crime, thus is equally entitled to fair investigation. In National Human Rights Commission, so and so Supra, commonly known as Godra riots case, the Apex Court has reiterated the requirement of the having a fair investigation and the trial. 96 minutes. On the contentions of the proceeding is that the referral authority is required to make the reference to the tribunal. After making fair investigation, no such proper and fair investigation is conducted, and the police at their own whims and caprice gives a report, in some cases even without visiting the place where such proceeding resides and also without giving any opportunity to produce the relevant documents to the substantiated, and the proceeding is not a foreigner, and as such report is accepted by the referral authority, and accordingly the reference is made to the tribunal on the basis of which the reference is registered against such person. 97. Fair investigation and fair trial being the basic fundamental and human rights of the person, which are concomitant to preservation of the fundamental rights of the person under Article 21 of the Constitution. There has to be a fair and proper investigation by the investigating agency before making a reference to the tribunal. In such investigation, the attempt has to be made to find out the person against whom the investigation is made, so that the person concerned is given opportunity to demonstrate and state itself there is not a foreigner. In case person concerned could not be found out in the village where he is reported to the reside or place where he ordinarily resides or works for gain, the investigation agency has to be record same in presence of the village elder or the villager headman or any as a respectable person of the locality who is in turn would ensure visit of the investigation officer to the place where the person ordinarily resides or reported to be resides or works or gain for making of an effort to find him out of his purpose of the giving him the opportunity to produce the documents, etc., if any, to demonstrate there is not a foreigner. The investigation officer, as far as practicable, shall also obtain the signature of the thumb impression of the person against whom such investigation is initiated. After recording his statement, if any, provided that he makes himself available for that purpose. There are also instances where person against whom such investigation is initiated changes his place or residence, maybe source of livelihood, or maybe about detection to ensure proper investigation and also having regard to integrity and sovereignty of the nation. Once investigation relates to the nationality status of a person asserts, he must inform the investigating agency in writing about the sense of his residence, if any, thereafter. In such persons, in case such person has failed to intimate the investigating agency in writing the subsequent sense of his place of the residence, the investigating agency has to mention the same in his report with his opinion relating to the status of such person on the basis of the materials collected at the place where he earlier resided. That will ensure a fair investigation and submission of the proper report on which investigation to the authority. Needless to say, such investigation need to be detailed or exhaustive on keeping in view of the nature of the proceeding before the tribunal and the object sought to be achieved. Hence, it need not be equated with an investigation conducted in criminal cases. 98. The reference by the referral authority also cannot be mechanical. This is very important. The referral authority has also applied his mind on the materials collected by the investigating officer during the investigation and makes the reference on being satisfied that there are grounds for making such reference. The referral authority, however, did not pass a detailed order recording his satisfaction. An order agreeing with the investigating would suffice. the referral authority also while making the reference shall produce all the materials collected during the investigation before the tribunal, as the tribunal is required prima facie to satisfy itself about the existence of the main grounds before issuing the notice to the proceeding. Para 99. Lord. Fair trial and a reasonable opportunity required to be afforded to a proceeding also includes supply of the certified copy of the public document, including the copy of the relevant electoral rolls, which has also been recognized by subsection 2 of section 6A of the 1955 Act as relevant documents for the purpose of the establishment of the citizenship to the proceeding, whether asked for is, which may be necessary for the purpose of the demonstrating by proceeding that he is not a foreigner. Certified copies of the such documents, if applied for, must be supplied promptly, otherwise it may result in delay in disposal of the reference proceeding, as the proceeding in that case may ask for time till such documents are made available to him. The same may also amount to denial of the reasonable opportunity of proceeding, as he may not be available to discharge his burden of the proof that he is an Indian national. In the absence of such document, such delay in disposal of the proceeding would also be against the national interest. The interest of justice therefore requires supply of the certified copies of such documents, that too promptly whenever asked for. Now, in the flowing paragraphs, more details more prescription has been
But
made.
the tribunal's notice and all.
Yes.
Right, nothing
Yes.
has to do with that.
Yeah.
Now, just as you have pointed out in the petition, come to page number 18.
Page number 18.
Do you have that book with you, right? This, the foreigners laws book with you.
Yes.
Come to the IMDT Act. Because Muslim Mandal entire case was, background is IMDT. Come to the IMDT Act, read section 8.
Section 8. Reference of or application to tribunals. If any question arises as to whether any person is or is not an illegal migrant, the central government may, whether such question has arisen on representation made by such person against any order under Foreigners Act 1946, requiring him not to remain in India or to any other effect, or has arisen in any other manner whatsoever, refers this question to the tribunal for decision. It is 8.1, 8.2. Then any person may make an application to the tribunal for its decision as to whether the person whose name and other particulars are given in the application is or is not an illegal migrant, provided that no such application shall be entertained by the tribunal unless the person in relation to whom the application is made is found or reside within the jurisdiction of the same police station wherein the application has the place of residence. Then number 3, every application made under subsection 2 shall be made in such form and in such manner as may be prescribed and shall be accompanied by affidavit sworn by not less than 2 persons residing within the jurisdiction of the same police station in which the person referred to in the application is found or residing, corroborating the abatements made in the application, and shall also be accompanied by such fee being not less than 10 and not more than 100 rupees as may be prescribed. Then 4, my lord, every reference under subsection 1 shall be made to the tribunal within the territorial limits of whose jurisdiction the place of residence of the person named in the reference is at the time of making such reference situated, provided that where such person has no place of residence, the reference shall be made to the tribunal within the territorial limits of whose jurisdiction such person is at the time of making such reference found. Then 5, every application under subsection 2 shall be made to the tribunal within the territorial limits of whose jurisdiction the person named in such application is found, or as the case may be, he has place of residence at the time of making such application.
Read 8A.
8A, my lord. Application to central government for reference. Any person may make any application to the central government for decision by tribunal as to whether the person whose name and other particulars are given in the application or is not an illegal migrant, and where any such application is received by the central government, it may, on the basis of the information it is in its possession or after making such inquiry as it deems fit, reject the application on the ground that the application is frivolous or vexatious, or it does not comply with the requirement of this section, or refers such application to the tribunal for decision. 8.2, my lord. Every application made under subsection 1 shall be made in such form and in such manner as may be prescribed, and shall be accompanied by declaration by another person residing within the jurisdiction of the same revenue subdivision in which the applicant reside in such form as may be prescribed, to the effect that the particulars mentioned in the application are true to his knowledge, information, and belief, provided that no person shall make more than 10 such applications or more than 10 such declarations. Then every reference under subsection 1 shall be made to the tribunal within the territorial limit of whose jurisdiction the place of residence of the person named in such reference is at the time of making such reference situated, provided that where such person has no place of residence, the reference shall be made to the tribunal within the territorial limits of whose jurisdiction such person is at the time of making such reference found.
Now please come to the 1984 rules. That
Yes,
you'll get at
84
page
rule is important, my lord.
478.
Yes.
Come to rule 3.
Yes. Rule 3 says, my lord, preliminary inquiry. For the purpose of making a reference in relation to any person under subsection 1 of section 8 and subsection 1 of section 8A to the tribunal, including consideration as to whether a question such as is referred to in this section has arisen in relation to such person. A, the competent authority sees the matter shall require the superintendent of police to direct, or where such competent authority in the superintendent of police himself, the superintendent of police shall direct any officer not below the rank of sub-inspector of police to make an inquiry. This is preliminary inquiry by in case of murder.
Read up to
4. Inquiry officer to proceed with inquiry. An inquiry officer who is directed to make an inquiry under Rule 3 in relation to a person as is referred therein shall call upon the person to give information as regards to the particulars mentioned in form number 1. Then 5. Power to elicit information. An inquiry officer may elicit information from any person who in the opinion appears to be acquainted with the facts and circumstances of the case in relation to which he is making inquiry. Diary to be kept by the inquiry officer. Every inquiry officer making inquiry under these rules shall day by day enter details of his inquiry in diary kept for the purpose setting forth may be as ascertained by him the time at which he began and closed his inquiry, the place or places visited by him, and a statement of the circumstances ascertained through such inquiry. In notice, yes, 7. Submission of report. On completion of the inquiry officer shall submit his report in form 2, along with the diary of his immediate superior officer, who shall endorse his comments thereon, and submit it to the screening committee referred to in Rule 8. Then, recommendation of the screening committee. There shall be screening committee at every subdivisional level, where the tribunals are established and shall consist of 2 members, on whom shall be subdivisional magistrate and the other a police officer not below the rank of deputy superintendent of police in the subdivision concerned. The screening committee shall, after scrutinizing the information contained in the form number 2 and the diary, make its recommendation to the superintendent of police as to whether the person mentioned in the report is or is not an illegal migrant. The recommendation of the screening committee shall be signed by both the income members of the committee.
read 9.
Procedure for making reference to tribunal. If on the recommendation of the screening committee and such further information as the competent authority may call for, it appears to the authority that a question arises as to whether any person is not an illegal migrant, the authority shall make a reference to the tribunal for its decision thereon, along with the following materials, namely the diary, number 2, the report of the inquiry officer containing the endorsement of the immediate superior officer, number 3, recommendation of the screening committee, and then number 4, such further information as that authority may consider necessary.
We'll come back at 2. What's your good name?
M. Kalita, Your Lordship.
Mr. M. Kulita, counsel appearing for the petitioner submitted. That. On 9/4/24, 2024. The petitioner Majibar Rahman Put back the brief from their chamber. And in that regard. Said Mazibur Rahman is given his signature and make a commendation. He has no objection if his earlier set of councils. If we choose the Okalat number. In his favor. From district. With regard to district. To that extent. Council Srimati Pallavi Budwan had shown an affidavit and filed the same before the court. Have you seen any registered letter to the petitioner?
No, no, Lordship. No, Your Lordship.
See, we have put the person Mazibur Rahman, you have his thumb impression,
Yes, Your Lordship.
but not been identified by anyone. Somebody needs to identify this thumb impression, right?
Lordship.
It may be anybody's thumb impression, it may be my thumb impression in that case, how I don't know.
We will do that, Your Lordship.
Mr. Kalita, current council, is allowed to inform the petitioner, Mazibur Rahman, about withdrawal of the names from this case by registered post which AD and to submit copy of such letter which has the receipt before the court on the next day. List on 14th.
Your Lordship, may I submit one more? Since I was assisting Miss P. Borwa, so my name may also be strike out. Your Honor.
We'll do it together. You send a letter.
Your Lordship.
Send a registered letter to the concerned petitioner. They need address.
Much obliged.
Yes, Mr. Pang. Now see the form.
Yes, I have seen a bit. Forms in the. Forms, form
Yes.
number 1 and 2, my lord.
Hmm.
As per the, this is.
If you read these forms, you
Yes.
will see most of these form issues involved in the queries
Yes, madam.
are also available in the present forms.
Yes, madam. Present forms in almost all the materials, whatever is there, my lord, these are also necessary in that case.
During the process of investigation. Let us.
Yes.
Now, is there any such procedure or is there any such rule under the Foreigners Act or a Foreigners Orders?
My lord, I am coming to that point, my lord. Before going to that, one more aspect, my lord, if your lordship may, because this is in particularly this case, my submission is this is totally irrelevant. What my lord?
There is another, have you read Sarvandas Annual 2?
Yes, madam.
The government tried to do similar thing, that's of the
Under
IMDT Act
2006,
1983.
2006 rules.
Same kind of form.
Yes, same.
And it has been set aside by the Sarvananda Sonal to judgment by the Apex Court.
In fact, Sarvananda Sonal 1, my lord, para 41 and 42 has clearly said whatever materials has to be collected from the petitioners, my lord, the procedure will not disclose those things who has come from the Bangladesh. They will not going to disclose all these things. So this is impossible on the part of the state to collect these materials. That's why these forms are not, my lord, what Sarvananda Sonal has said. These are not necessary. But
There was a delay after 2005, you see that the government did not take, state did not formulate any procedure, right?
yes,
Then the second case, when they came up with this, it was challenged in the Sarvananda Sonal 2.
yes,
Therein that, I think in the Sarvananda Sonal 2, that form is also there.
my lord, yes. My lord, 2006, the government has made a rule to vitiate the, my lord, first one. So 2 has come up and 2 has set aside the second 2006 rule also. So that is the fact. But in the present case, my lord, the issue is something different. Because the present case is coming from the LVO report. It's part of ERO report. It is not, my lord, what my submission is that my learned friend has argued, senior friend has argued that my lord, Muslim Mandal, the para 97, I may accept in some.
You have to accept it
Yes,
because it is
yes,
full court
but
decision.
yes,
Full
but my lord, the Muslim Mandal has no link, has not discussed anything about the digital matters. This is totally of police report, cases on police report.
Nothing to do.
This is nothing to do with my present case. Because
they did not call the Muslim Mandal case was totally background by IMDT Act and it was a police inquiry.
it was on the basis of police inquiry.
So this
But
is not-
present case is not police inquiry. It is on the basis of ERO's report, my lord.
But in that case, even if it is an ERO's case, it's not there seems to be some report.
My lord, there is a report. That's why, my lord, your lordship may kindly see. What is, my lord, your lordship may kindly see.
There is a guideline from the election commission, Lord, so that has to be referred.
Yes, in one of the case, I remember it was placed. In fact,
fact, my lord-
in one of the judgment have dealt with.
Yes, my lord.
He was there.
I would like to, that is Sayamuddin, my lord. And in fact, that, my lord, the 97, that was challenged in the SRA Sudhuri's case. Yes.
Right.
That is, my lord, 2002, 1 GLT, my lord, 1. SRA Sudhuri 1, that is. 2002, 1 GLT, page 1, my lord. That is SRA Sudhuri. I'm coming to that point. But prior to that, my lord, your lordship may see the guideline. My lord, there are 8, your lordship may kindly see 8.6, 8.4.
Where?
If there is a marking internal pages in also, page 31.
Nice.
8.1 or 6.1?
8.3, 8.4, my lord. 8.
8.5.
Yes.
8.5 lordship.
Your lordship may kindly see the 8.5 onwards. In all other cases, your lordship may kindly see. Yes, in all other cases, of persons mentioned in 8.1b above, the electoral registration officer shall cause a local verification to be made by the local officer. That is LVO report, madam. Local officers whose service says the electoral registration officer may use in this regard should have the prior approval of the chief election officer. In no case, the teachers will be appointed as local verification officer, nor should any other officer who was actually engaged in the physical enumeration work in the area of engagement for the purpose. Now, 8.6, madam, this is important. The local verification officer will conduct the verification by making an on-the-spot visit and on-the-spot visit, and the person concerned may adduce in support of his claim as citizen of India any one or more of the following documents of the evidentiary value under the Indian Evidence Act. They have given some documents, madam, which the local verification officer could verify. Then, madam, after due verification, 8.7, the list of documents are given, madam. After due verification, as mentioned above, and the documentary evidence adduced during such verification, the local verification officer shall submit his report in the form of Annexure A. That is the annexure A, which my learned senior friend is agreement. Now, then 8.8 manner, the election officer on receipt of the verification report, this maybe similar report from the local verification officer, consider the same. When he is satisfied on such report and such other materials, information as may be available to him about the eligibility of the person, he shall allow his name to continue on the rule and include it in the final rule. This is very important, man. My lord, yes, the 8.8, my lord, the electoral registration officer, my lord, electoral officer, registration officer, he make a, prior to that, my lord, prior to verification, the cause was, my lord, when the electoral ERO has seen, the electoral officer has seen that this person's names have been suddenly appearing in the voter list of 1997, then he caused a doubt. Then when he made a doubt, he has, after extensive revision, he found a doubt that this person's name is suddenly appearing, how he has come, where from he has come, why his name was not prior to this, suddenly. So he made a doubt, he make a inquiry, make an order to the, make an inquiry by the electoral registration, this LVO, madam, to make an inquiry by the LVO that whether his name can be continued in the voter list. For that purpose only. If the LVO can collect some documents, some materials against the inquiry inquiry directed by the ERO, then his name can be continued in the voter list. But if the LVO cannot produce anything in his report to the ERO has no other option but to send the matter to the foreigners tribunal for reference. Here is the case, my learned senior friend is arguing in other ways. So they are saying because as the LVO report has consisted nothing, so you cannot send a report, send the matter to the tribunal. That is not the case. The case, because it is clearly said, madam, the electoral officer shall on
In that case, the
madam, the record will say prior to LVO report, there is an order by the ERO that make an inquiry whether this person's name can be continued in the voter list or not. His name
here,
is
of course, Election Commission is not a party, but the ERO is a party.
yes, ma'am.
Mr. Kuli, will you appear?
Yeah.
For Ali?
Well, this is settled position because the later on the division bench of this honorable court in a writ appeal also this matter has been settled.
No, regarding, because I remembered in one judgment I read Justice Yu Hian,
Yes, my lord, there is a judgment.
but this was considered.
Yes, this was considered, my lord. Your lordship, can you see? This is my lord WPC 91 of 2019, Sayamuddin. That was upheld by the division bench, my lord. WPC 91 of 2019 and writ appeal 170 2019. These are the two cases. In fact, the first one was
No, there is a judgment of division bench.
yes, division bench is there, my lord. Writ appeal number 170 2019.
Who is the author of the judgment?
Authors, this is by the Chief Justice acting and his lordship Manish Chaudhary.
No, prior to that,
Okay, Goswami sir.
there's two forms that
Yes.
LVO's forms
Yes,
and the
they-
PRO's form.
they have
been
considered.
discussed in one of the judgment by Justice Yu Hian.
No, that is a single bench.
Single bench sir, judgment.
Then that was
That was
went for the division bench.
went for division bench for appeal. In appeal, both is this two what is it? Everything this has been quoted, my lord. These provisions have been quoted and discussed.
Mr. Mondal. Take down the numbers, you go through these judgments and then we'll have on the next day. Because if the issue have been decided, will not go further. WPC 91 2019 decided on 19th of February 2019. Then read the page.
Exact.
170/2019 decided on 29th of July 2019.
That effect, my lord, the Isari Suduris case 2002.
That is
on the-
considered in the
Yes,
read
that,
and as well as the single bench.
yes, ma'am.
You go through and let us know
Well-
whether it has been the issue that you have raised, has been taken care of in that case. Except. Thursday next,
Item Lord, election with action. Election, so.
so
Election,
you're going to Dhubri or not?
yes. Can it be after 10th, my lord?
Place this matter for hearing on. Okay.
After 10th, you want?
10th May is a Friday. Will not have on Friday.
14th or
Yes.
16th?
14th May,
14th or 16th?
Yes, 14th or 15th, my lord.
we'll have it, keep it on 14th.
My lord. Now
Mr.
the.
Pine, give us a copy of this. Just go through.
Yes, sir. Mulata, so far this Mulata prescription is concerned, that has been decided by this honorable court.
Let us see, because I
We have a Mulata authority.
we'll see to that.
Yes.
Because if you read, that is why I say that if you go through,
Yes.
there is an interesting part here in the Muslim mandal.
Yes. Lord, what has been submitted, my friend, Lord,
We are not. discussing-
assuming, Lord, there is a vacuum, then Article 14 and 21 will play. It is not that we are helpless, the citizens are helpless. But there is no rule of law, then Article 14 and 21 will come.
It's a
In the
settled-
manner you inquire,
There is no
You
violation
inquire
of
in the
any
Mullah
principle
air.
of natural justice.
you inquire in the air, submitted the report before the superintendent of police, who without going through the materials on record, referred the matter just to the tribunal. Mechanically, that
But-
cannot be.
My son, my,
There is a rule of law.
It is an on-spot verification. There is no inquiry as a scrutiny.
Tell them any
is required.
person they have examined,
It's not
my lord,
required.
tell them any person they have examined during my interrogation.
what
There
my
must
lord,
be person, my neighbor is there.
LBO is their person, my lord. LBO is appointed for their benefit only. If they do not provide anything to the LBO, it is their fault.
There
LBO
may
is-
there may be enmity between the LVO and me.
I don't know. This is the ERO. ERO has given the, you have been given the opportunity through ERO, through LVO. It is the LVO who could
ERO
reverse
has
the
never
opinion of
visited
the
my
ERO.
residence. I have inquired, I have total in report, ERO never inquired into my
My
place.
submission is that if
Never visited my
if
place.
LVO does not give any report also, then I have no other alternative but to send him his name for tribunal. Because the ERO has doubted already, because his name is appearing suddenly in the voter list of 1997.
No, that
This
is
is the-
wrong, absolutely wrong. My name appeared first time in the year 1977. What
That's-
you are talking?
No, that's why how his name appeared in the voter list,
1977, my name first appeared.
that was not produced. 1997, his name is sometime. That's why the ERO, when extensive revision was done, when there is some doubt, there are some issues, my lord, if your lordship will find there.
Now, the lady I am representing, my lord, she is about 70 years old. Now I had my lord, a telephonic talk. She is now bedridden.
That
She is
a
about
different- that is
70
a
years
different
old.
issue. The-
And her name first time appeared in the year 1977.
what were considered, everything was there, madam. Person who's attained the age of 18 years on 1st January. Person enrolled in the other constituencies within the state who have shifted to the constituency. Persons who have entered Assam from Bangladesh between so and so, between 66, 71. All these were considered by the ERO. then only he makes the order for LVO, local verification.
I have a doubt, I want without.
Yes, it is the ERO who, when ERO doubts, my lord, he can refer the matter.
He could not create a doubt, that's why it was referred.
And for his clarification, whether his name can be continued in the voter list. For that purpose only, he referred the matter to the my lord LVO for a verification. If LVO cannot give any satisfactory my lord documents or materials to the ERO will have to send the matter to the tribunal. Because there is a doubt. Doubt has to be clear.
Now,
The LVO is appointed only for
now let
verification
them
of the
show,
doubt.
my lord, whether any witnesses were examined by the LBO.
That is not our duty. That is LVO is your
That is your
person.
duty.
The
That is
LVO
your
is
duty,
your
state
person.
duty.
Come back. Let the letters go to that.
Inquiry made against me.
It was silence.
No
This
witness was
provision,
examined.
these provisions were silence. This provision is there in the guideline. These guidelines were silence in Isari Soduri case. That was upheld by this honorable court. That is settled already. If this was silence.
It's an,
Obliged.
Lordship, kindly pass over the matter for the time being. Machinery is on back, so Lordship.
Six or eight.
Lordship, 8.
And they will be considered for the tribunal list on 8.
May I please, your lordship, my senior is election code number 15. Can we show this matter and will be taken after 2 weeks?
Ninth. For hearing on the chair because.
Lordship, I'm seeking adjournment in this case, Lordship, may be taken after a week, Lordship.
Now somebody.
14th.
Deeply obliged.
Please, my lord. My lord, here we are the appellant in this case, and we have filed this bail petition under section 21(4) of the NI Act.
How much time you are going to take?
My lord, not much, but this matter is of bail and it has been pending since a long time, my lord.
Are you rejected?
Earlier rejected, my lord.
Events where my sister was
My
there.
lord.
My lord, my lord.
And that is why the matter is placed before lordship.
Sixth, Monday.
Monday.
My lord, if it is possible today,
Today court will rise within half an hour. I have also seen events in other division. The other division bench will not be possible today.
References.
okay, okay. My lord, on 6th. Sorry.
Hello. You are there in the other division, right? Justice, Madam Justice Takuria, I don't think so we're able to sit with you. We have time constraint.
When will the next?
We'll first ascertain whether sister is available next week or not. Subject to her availability next week, we'll give you a date sometimes around Thursday or something like that. Thursday or Friday, we'll see. But subject to her availability next week, we do not know whether she is available or not. You inquire later from the bench. Sixth.
My lord.
Just a minute. your main prayer for bail on the ground, because earlier rejected by the court, that's why
Yes.
you're asking.
My lord, the prayers have been on the earlier occasion, they have said that after 4 years to appear before this honorable High Court. And accordingly, we have filed the bail petition in the lower court itself, in the trial court. And same aside, we have come here before the honorable court for the bail petition. My lord, the operative part is at page number 162. Criminal appeal. Para number 91.
He is in custody since when?
Since 4 years, my lord. Almost 5 years complete. Since the month of April 2019.
Mr. Das, what will be the main ground of your rejection?
My lord, here your lordship has to go a little bit because they rely on K. Najib case.
That's right.
But that has gone a little bit of chase by a recent judgment, my lord. I'll be placing you forward. So,
Now, what all you want to know? He was
Once-
a sympathizer, or he was being a sympathizer, he was also involved.
my lord,
What is the reason for objecting his bail? After 5 years, almost 5 years.
but quite true, but
There are-
in the latest judgment matter, Supreme Court says that there is no matter. Maybe it has taken time, but Najib case, my lord, it was decided that that is a Kerala case, my lord. What has happened, my lord, there, about 7 accused, they were already sentenced to jail for 7 years. Only on that ground, the court has taken that Najib, if you would have convicted, he would have given maximum
See,
5, 6
basically,
or
in
7
the
years.
19th.
But here, in
No,
this
no,
case,
bail is a rule.
Um,
Jail is not the
But
thing.
bail,
But under
that has
the-
that has also that has already been taken care of. But
Yes, so we know that in the 1967 Act, that is not the case. There's been law laid down by the
But-
apex court, right? But there has to be something reasons for that.
Man.
Or to alter that sense, because 67 Act is different compared to other penal provisions, right? So that is why the apex court in the 67 Act has clearly said, they said probably doesn't apply in the cases of the UAP Act. That's what the view is. But for that purpose, you have to establish certain things,
Okay, yes, yes,
right?
yes. Your Lordship.
Let us see.
Which case you want to rely? Which case you are stating?
Okay, brother.
Which case you want to rely upon?
My lord,
Alright.
one more thing, one of the
This-
co-accused in this
this is-
particular
this
case
is
have been
recent
granted bail recently.
Gurinder,
Gurvinder Singh.
Gurinder.
Your possibly, your Lordship has.
Yes,
seen
yes.
it.
The Govinda
Hello,
case is little
we'll take it
different, my
later.
lord.
Yeah.
The facts of the case.
The
might,
facts of the case is
change
totally
or
different with
The
regards-
thing is this, because in that Gurvinder Singh, the court has considered a suspect that though it is, jail is not the rule and the bail is rule, but in the case of UAP Act, it is different. The why it is different, it has been placed there in this case, right?
But the scenario of that case is totally different with this scenario of this particular case.
Okay, we'll consider it on Monday.
Hello.
The, Mr. Bhattakur will sit at 3 lots. The single bench will sit at 3 lots.
This, get it later, 6, 7.
6
Mr. Das will have it on Monday.
Next. I'm appealing for the respondent, my lord.
Yes, yes. Hardly.
Wait, Amar.
What's your good name?
Dean on this.
For the petitioner. And Mr. Dedas Leonard Singh Council. Assisted by D. Borogoy. D. Borogoy's counsel for the respondent and I. The prayer of the council for the party is list on 638. Okay. October 11, 15,000 going.
মাতি দিয়ক শুনি আহিব
তার সিঙ্গল লিস্ট নাই নাকি এনেকে রাখো
Sharma. Take your seat. We have allowed the bail with certain conditions. Continue.
Deeply obliged.